Succession planning, equity.
I'm Jennifer Harrington. I'm currently an attorney who practices at a law firm up in Algona, Iowa, the Buchanan, Bibler, Gabor, and Mice law firm.
Looking at equity.
I think a good way to kind of approach this is like when a family comes in, or I would say usually it tends to be a couple, but when a person comes in for estate planning, and I know that there's an ongoing farming operation in any permutation, kind of how do we approach that conversation? There's kind of two different things that I like to bring up to their attention. And the first is, in any operation, we really have to talk about two different things when we talk about estate planning or succession planning. And then the first thing is both the management of the operation, who's going to be making the decisions when you are not doing that anymore, either voluntarily or, because circumstances don't allow you to. And then we also, the other side of that is who gets the equity, right? Who's going to get the financial benefit of this operation? One, you, right, while you have it and you need it, but then also what's the plan for when you no longer need that, right? When you're no longer here, who's going to need financial benefits from the operation, right? Does your spouse need to continue to receive income but not work on the operation, or are they going to continue to work on the operation? And then inevitably, we also kind of usually have to plan for a time when you're getting something off the operation, right? You've put in a lot of work over these years, and you're in kind of like, we'll call it retirement mode, right? You're probably not putting in as much as you were back in the day, but you are still drawing that income because that's what you need. So that's one kind of set of way of framing kind of the decisions we make, right? On all the decisions we're making, what's the consequence to both the management of that operation and what's going to be the consequence to kind of the financial benefit of the operation, right? Who's going to be receiving the financial benefit and what work's going to be done for that financial benefit, if any. So that's one set. And then the other thing that I think, especially when you're talking to an attorney about this area, that's good to talk about is we have to remember, are we talking about like a legal decision, right? Like how is this framework going to create legal consequences about what decisions can be made later? Or are we kind of talking about a tax consequence? Now, and I know those two things can get very blended sometimes, but sometimes a lot of our planning gets very focused on, well, this is because this is the best place to be from a tax perspective. And that could be true, but there are a lot of people who are willing to pay a few $1,000s more in taxes to know that the family's not going to fight, right? To know that we have a better solution out there. And so sometimes we kind of need to remember, like, are we really talking about a tax consequence and that's the reason why we don't want to do this? Or are we talking like legally that's not allowed, the courts are going to throw it out, we just can't do that? And so it's kind of, I think it's good to work with a professional who can kind of make sure we're in the right framework for either one of those conversations and knows kind of the difference between those things. So those are kind of the two things, or the two pairs I like to tell people to kind of keep in mind, especially when you're down in the weeds about kind of an issue, right? Like usually about a half an hour in, we're really kind of maybe talking about a specific situation or a specific asset. Sometimes it's good to take a step back and say like, hey, are we really, what's the issue here? Is this kind of a management kind of thing that we're concerned about? Or is this kind of a financial benefit thing? And then also, is our concern more of like, legally, I'm not sure my plan's going to work out? Or is it, I'm afraid I'm going to lose this tax benefit we're planning around, right? Because that can kind of help frame what solutions we're kind of going to go forward with. So I think that's kind of a good way to kind of frame making some of these decisions that I think probably I'll have some more questions about as far as kind of succession planning goes.
Understanding basis.
So a lot of the times when we're planning, even without saying it, a lot of attorneys are really kind of talking or planning around kind of what we call basis planning. So the difference between gifting, selling, and inheriting really has a consequence in the tax world. From the legal perspective, you've transferred ownership on all three of those. And so that's great, right? And that new owner can do what they want with that asset once they have it. So from a legal point of view, that transfer creates the same consequences. From a tax perspective, it creates a very different consequence to the person that you gave it to, right? There's a different tax situation for all three of those situations. And that's the tax situation is for basis. Simply put, basis is the value of an asset for tax purposes when you go to sell that asset. And so determining whether or not you sell it for more than that basis determines whether there's a gain. If there's a gain, you may owe tax on that gain. Capital gains is kind of the term, right? The capital gains tax. Technically, if you sell it for a loss, sometimes you can take a loss going forward. Again, big asterisk here, right? It really depends on the situation and how that asset's been treated in the past before, I can say something so broadly like that, but that's the general concept. So that number for tax purposes, that basis number is different between gifting, inheriting, and selling.
Tax perspective basics: gifting, inheriting, selling.
So if you gift an asset to somebody, they get that asset with the same basis that you had it. And the example that everybody uses for this really is land, because it's an asset that pretty much appreciates over time pretty uniformly, right? Sometimes it goes faster than other times, but over time we can consistently say it appreciates. So if you received land, and we're going to make things very much not realistic for Iowa farmers, I'm going to say this first and foremost, but say you got your land and you bought it for $1,000 an acre, and now you're going to sell it for $5,000 an acre, right? That's the fair market value. You got it for $1,000, we'll say back in 1990, okay? This is magical ground here that was expensive then and low cost now. But it was $1,000, right, when you bought it, okay? And you've held on to it and you think, okay, I'm gonna give it now to Junior. If you gave it to Junior would have it with $1,000 basis, right? If you give it to Junior in this year. If Junior goes around and sells it at $5,000, that fair market value, he's going to pay gains tax on that the difference, right? That $4,000 an acre, right? And he's going to pay his capital tax rate on that. If instead of gifting it, we wait until you pass away and then Junior gets it through inheriting, right? At that point, Junior's going to receive the land at fair market value. His basis is the fair market value. So he's going to hold it with that $5,000 an acre basis. If he goes around and sells it right away, then there's going to be no tax paid, right? And that's kind of called the step up in basis concept. And if that didn't make sense to you, feel free to go to the video place of your choice and do, step up basis, tax explanation 101. There's a lot of various extensions, universities who kind of explain these concepts to economics students in very fun ways that are more engaging than me. So it's a concept that's worth understanding if you're in this realm. So you need to understand basis, but when we plan then, because of when you die, you can get that step up in basis. A lot of estate planning is meant to kind of create that tax goal of making sure that we can get your heirs the assets that you have with the highest basis possible. Because then if they choose to sell it right away or even later down the road, we've minimized the tax consequence to them. So that was the two, right? We've talked about gifting and inheriting. And then you say, well, what about selling, right? What happens when I sell it? And in general, when you sell it, that person their basis is what they paid for it. Now, again, I say in general, because we're in this area, succession planning, And selling to a relative comes with a lot of different regulations under the tax code. So, you really kind of have to pay kind of fair market value when you're dealing with a related party, or get an appraisal, or else the IRS might say, okay, that's a part sale, part gift. And that, again, that's fine, but then we kind of have to do a basis allocation, and we need to make sure, and you need to talk to the person helping you out with taxes. You need to talk to them to make sure it gets documented correctly, so that if a sale of that asset ever comes down the line, we actually know what to do with that tax-wise, and we're not paying to get a retroactive appraisal 10 years later.
The difference between a will and a trust.
Yeah, so will versus trust. I guess the first thing we have to talk about is, there are a lot of different types of trusts out there. Trusts are a legal concept. There is a trust code, right? So there's a chapter of the Iowa Code that all deals with like trusts and how you create one and their administration. I think most other states have it as well. Again, like kind of a set of laws about a trust. Ultimately, a trust in its bare bones, like if I could almost, and it is oversimplification, a trust becomes a different owner, right? The trust becomes the owner of an asset. And then the trustee, right, the person who's kind of in charge, has the management. And then the beneficiary of the trust has the financial benefit, right? So we kind of, when we talked earlier, we have, both the management and the equity. In a lot of ways, a trust is a vehicle that's very easy to kind of break up the management responsibilities and the financial benefit, right? It's a legal creation that set itself up very nicely to do that. So that is a trust in its entity, or at its core, right? And there's a variety of reasons why you put things in trust. It's basically when you want somebody to not have all management rights, right? And so traditionally, sometimes we see trust for like people who don't have the ability to handle their money correctly, for a variety of reasons, either kind of capacity reasons or just not financially savvy enough. So that's a trust, like just a trust, and there's a bunch of, and then there's a bunch of different types of trusts. So when we get into estate planning, from a legal point of view, right? From a legal, not a tax, but a legal point of view, we're seeing a rise in something that's called a revocable living trust, right? Or a revocable trust, or a living trust. So a revocable living trust is a trust that you create during your lifetime. And it means that you can kind of change the trust up until you pass away. And we're seeing a rise in there because the main benefit of those is that you avoid the probate process after your death. Probate, and this is kind of where we kind of get into like vocabulary soup, but probate stripped down is really just the court oversight of taking your assets when you die and making sure they go to the people that you want them to, and that all your debts are paid, right? So after all your debts are paid through the probate process, any assets remaining go to those people you want them to if you've created a will, and then that person, those people will own those assets free and clear. And there'll be a paper record showing that that asset was owned by you died, and therefore it went to that new person, and that no liens were attached to it. All the debts that could be associated on that asset have been paid, right? And it's gone to this new owner. That's what probate does at its core. Now that costs money, as you might imagine. So in order to kind of avoid that process, it's also public record, right? So probate not only costs money, but it is public record. And there are people who say, hey, you know what? I don't want anybody looking at what I owned at the time of death or who I gave it to. Okay, so a trust would also avoid kind of the publicity that's associated with the probate process. And so I think kind of those two reasons are why we're seeing kind of a rise in the revocable trust. If you have a business that's worth money, a lot of the times having a revocable trust or creating a revocable trust is actually cheaper than what the probate fees would be. Now, I want to be very clear. I am talking about the probate fees of like the court costs themselves. Okay. A trust, an executor is still entitled to a trustee after your death is still going to be entitled to a fee for trust administration, just like an executor gets a fee. It's not statutorily set in a trust, but they can be high hourly rates if that trustee wants. It's kind of what is generally accepted around the area is kind of the default under the code. And then also you tend to have attorneys involved with both, right? So there are attorneys involved if you do the probate process through a will. And then there are also attorneys involved when you die through your trust administration. So it's not, I have found, at least in my practice and around my neck of the woods, it's not necessarily cheaper from an attorney cost perspective to do a trust versus a will. And I guess another thing that I do want to bring up with probate, because we kind of talked about the cons of probate. Some of the pros of probate is one, court oversight itself. So because there is court oversight, there are deadlines. And so we know things are going to be done by a certain time because the court is actually going to say, hey, where is this? When is this going to get filed? And things can become delinquent. You don't really have that so much in a trust. And so sometimes we see trusts can kind of sit a little bit longer post-death just because we don't want to touch that, right? We don't really want to dig in and really have to like work through it. The other thing is you have a built-in judge, right? Like probate has a judge. And so if you have a beneficiary or an heir that's likely to be problematic, or just kind of throw a fight to throw a fight, sometimes through the probate process, it's just easier. They'll have 30 days to kind of say, this isn't how it's going to go. I contest that. And then we have the hearing and it's done. Trusts, if you have an unhappy beneficiary in a trust, sometimes that litigation gets pretty lengthy because they sat on the problem for 3-4 years and now they're alleging wrongdoing for 3-4 years. And so because of it, it just kind of becomes an even more expensive litigation process. So that's just another thing to kind of keep in mind. I think sometimes there's this idea that a trust is something you need to have, probate something you need to avoid. And that's not the case for everybody. And then also, sometimes trusts are really expensive to create, and cost savings wise, probate court costs and probate in Iowa are actually pretty low. So it's sometimes worth actually doing the cost analysis of having a will might actually be cheaper.